The live stream will begin shortly. Please note that RapidVisa is not a law firm and is not licensed to practice law in any state. The hosts of the show are not attorneys. RapidVisa is a document preparation firm, licensed and bonded in the state of Nevada. We will do our best to answer informational questions during the stream based on our experience in helping tens of thousands of customers successfully apply for their immigration petitions. However, if you need legal advice, we advise you to seek assistance from an attorney. Please post your questions in the comments section during the stream for a chance to win a $100 RapidVisa credit towards a future service. Now, enjoy the show.
Hello everyone, welcome to RapidVisa Live, now streaming on YouTube and Facebook. Ask your immigration questions in the comments section during the stream for a chance at a $100 RapidVisa credit towards future service. Stay tuned because the winner will be announced at the end of the show. Please try to make your questions thorough and in one single comment so we have enough information to address them. I'd like to introduce Pam today as she'll be joining us on the live stream. And Pam's going to share some information, immigration news, and about some information on a new product that we're bringing out.
New tool, yeah. Thanks, Rick. Okay, we'll start out with some news. Trump executive order to enforce legal responsibilities of sponsors and co-sponsors. The White House recently issued a memorandum on the enforcement of legal responsibilities of immigrant sponsors and joint sponsors. The memo directs relevant federal agencies to update procedures, guidance, and regulations to comply with current law and ensure that ineligible immigrants do not receive federal means-tested benefits. So what this means is when you sponsor an alien and you sign the affidavit of support, you are telling the government that you are vouching for that alien and reassuring the government that you are financially responsible for that alien and guaranteeing that they will not become a public charge or receive any means-tested benefits. This has already been law since 1997 under Section 213A of Immigration and Nationality Act. By signing an affidavit of support, you are telling the government if this alien ever goes on food stamps or Medicaid or any federal means-tested benefits, the government can come after you to reimburse the Treasury for those expenses. So while it's already law in practice, this has historically rarely, if ever, been enforced. With this new update, the administration is making its intentions clear to start enforcing this rule. All sponsors and joint sponsors should take this into consideration when signing an affidavit of support and understand the magnitude of the decision to sign it. When we hear any new developments on this, we will be sure to bring it to you. In another announcement, we have launched a free tool which allows K-1 fiancé visa applicants to gauge their possible risk level of receiving an RFE or request for evidence. So RFEs are more common than ever, so knowing your risk level might help you give ideas on building up your bona fides before applying. You can go to the URL on your screen and just enter your criteria and we'll give you a score. Please keep in mind that just because you get a low score doesn't mean that you are immune from getting an RFE. In fact, many cases which are perfect still receive an RFE. So inversely, if you get a high score, it doesn't mean you can't overcome the issue. Most RFEs don't result in a denial, only a delay. So most of them end up as approvals. Again, try it out. Go to the URL on your screen.
Okay, first question comes to us from YouTube viewer. How many days after we send them the RFE documents do we receive the NOA2? First NOA2 is Notice of Action 2. That's usually the approval notice. And what we're seeing right now is usually about 2 to 3 weeks after submitting the requested documents along with the original RFE letter, they're usually issuing the approval notice. Now, again, that's just an estimate and it really depends on the type of RFE you're receiving. Some RFEs or requests for evidence take a little bit longer to adjudicate or review and process, but average is about 2 to 3 weeks.
Okay, next question is from Shili Lania. Do divorces have to finalize before you can file for a fiancé visa? Yeah, absolutely. So it has to be a final decree or judgment of previous termination of your marriage. So most states have this cooling off period. They usually issue a decree and then give like about 3 to 6 months for it to become finalized. So within this period, you should not be filing any application because it means that your divorce has not been finalized yet. In other countries too, outside of the United States, they have this period to appeal. So from the time the judgment was entered by the judge, they usually have 15 days to 30 days to appeal the other party, the losing party. So within these days, the divorce is not yet final. So you should be able to file the application after you receive the final divorce decree, which is issued by the judge where your case was filed.
Summer on Instagram states that I would like to get started on my K1 fiance visa, but not sure how to get started. From what I've read about it so far, there's so much that goes into it. I would like to know how to get started. The easiest way to get started with us is to go to our website at rapidvisa.com, and you'll create a free account and simply answer a few questions in our online questionnaire, and we walk you through the entire process. We'll provide all the forms, documents, letters, and everything you'll need to file your petition. We'll also provide you with a detailed checklist of all the supporting documents that you'll need. We include a roadmap with everything to expect throughout the entire process. Now, if you're looking to do it on your own, the best place to start is at the USCIS website. You can get the forms for free. It's a little bit complicated to navigate around the USCIS website, and that does not complete the whole entire process. After that, then you need to go to the Department of State or National Visa website and to find additional instructions for the embassy and medical exam and things like that. But if you go with our service, we just roll everything out for you and provide all the details, documents. We hold your hand through the entire process. And then, of course, we're available to answer any questions that you may have. And we support you from start to finish. That's all the way at the USCIS stage, all the way through the embassy stage until the visa is issued. Then we also support you with adjustment of status to get the green card, and then removal of conditions to renew the card, and hopefully on to naturalization or citizenship.
Okay, next question is from Frederick Anderson. I'm about to go through the AOS process. When is the best time to get the medical examination? Okay, so if you are, if the alien beneficiary entered via as a K1, you should be filing your fiancé, the adjustment of status after you get married, but before the medical examination expires, which is 1 year from the time it was issued. I'm talking about the DS 3025 here, because this is the medical examination report that is used by K1 applicants. Well, but if you are if you entered in the United States other than K1 visa, using visa other than K1, then you should be using Form I-693, which only has an expiration days of I think 60 days. 60 days. So yeah, you should get it at the last process of, so that to avoid it being expired, since it only has a validity of 60 days from the time of filing. So so that's it. It definitely has a difference if it's a DS 3025 or I-663 medical examination.
Nawana on YouTube states that I am a student in North Cyprus and I want to come to the States for a conference. What are my chances and documents needed? So basically you're going to be filing for what is called a B1, B2 tourist visa. It's a visitor's visa, and you would file an online form called DS-160. And as far as your chances go, it really depends on your ties to your country. When you're applying for a tourist visa or a visitor's visa, the consular officer wants to see that you have strong ties to your country and that you're not going to stay in the United States. And then we also have an odds calculator on our website at rapidvisa.com. You can go through that, answer a few questions, and it'll actually provide you the odds. So it's a good way to start. Keep in mind though, with the odds calculator, you have a low odd of getting, low chances of getting approved, sometimes you can overcome those. And you can give us a call and we might be able to help you with that. We also provide tourist visa, B1, B2 tourist visa service, and it's $99. And take a look at that. We provide you with a detailed checklist of supporting documents you'll need. To prove that you have strong ties to your country, you're going to need to show that you have maybe a good job or a business, you have family ties, children, spouses, things like that. So they're also going to want to see that you can afford the trip. So they may ask you about your bank account, how much money you have in there, to see that you'll be able to not only get to the States for the conference, but be able to return, which is more important. That's really what they want to see.
Okay, next question is from Mimi Peralta. A year ago, I petitioned my ex-fiance. The relationship ended while in the process. I received the NOA that it had been approved but never went forward with anything. Does it affect any future K1 petition? First of all, you have to check the status of the first petition that you filed, because if it's still pending, I don't think you can file two K1s at the same time. You have to make sure it's already, terminated. But if you're going to file another K1, then make sure that you're able to disclose your previous filing, because it is necessary. A lot of our customers don't, maybe they forgot to disclose it and they end up with RFEs and even like denial, because it's very important that you have to disclose everything on the form. And if it was filed a year ago, maybe you will also need a waiver. It depends on your situation, because it is a requirement under IMBRA that you have to execute an waiver. So, but as I mentioned, it depends on your situation. So I think that's the only thing I could think of when filing another K1 petition.
Mike Berthoud on Facebook asks, what is the most common reason for denials during the interview phase? My fiance is really stressing out about it. With the fiance visa, the number one cause for denial is usually the affidavit of support or proof of income. Most denial letters that we see state that the applicant is possibly going to become a public charge and collect means-tested benefits. That's probably the number one reason for denial that we see. Number two denial is not providing adequate proof that the applicant intends to marry within 90 days. Otherwise stated that they haven't proved that they have a bona fide legitimate relationship. To do that, you want to show that you intend to marry. You may want to show wedding plans and have sent out invitations, maybe have an engagement ring, show pictures of an engagement party, things like that. Now back to the income portion, you're going to need to provide your affidavit of support. You want to provide W-2s, proof of your income. That could be pay statements, bank accounts, things like that. And you can find the income requirements on form I-864P, and that's the HHS poverty guidelines. Take a look at that. And a lot of people think that just because I'm barely over that limit of 16,000 and some change, they think they're good to go. But what we have found is that you really need to be a little more over that, and to be in a comfortable zone. Because if you're close to it, you're probably going to receive an RFE. That's a request for evidence. They're going to want to see maybe assets. In some cases, they may want to see a joint sponsor. If your fiance is from the Philippines, though, unfortunately, that's one of 5 countries that do not accept joint sponsors for the fiance visa. They do for the spousal visa, but not for the fiance visa.
Okay, next question is from Facebook's, from Sohail Khan. My K1 visa was refused to consular officer. He told your case sent back to NVC or USCIS. So my fiancé didn't receive any letter from the USCIS. Can we file a new I-129F during the interview? So I'm assuming your case, if it was sent back to the NVC or USCIS, it is now under administrative process. So it means that they want additional proof in order to make a decision on your case. Probably your fiancé got the 221G. So yeah, this is what happens when they send back your case to USCIS. They could not decide your case, and you have to submit additional evidence. So just make sure you are able to comply with that. But could they just be denied outright during the interview?
They can.
They can.
We're seeing cases now where they're able to deny cases without even submitting an RFE or request for evidence. In this case, they're asking if they can apply again for an I-129F, and the answer is yes. But you want to make sure that you do not have an active case pending with the Department of State. What that means is wait till you have your final decision and the case is closed. Or if you decide you want to apply again, you may want to submit a letter requesting that this case is closed. The last thing you want to have is multiple active petitions in the system or on file, because it may appear or look like immigration fraud, something like that. But I would follow up on this case and just find out what the exact status is. You can check the status online, and depending on where your case is, whether it's with the embassy or they've sent it back to the USCIS, that's who you'll contact. Because if you contact the embassy and they've already forwarded your case on, they'll tell you they no longer have jurisdiction over your case. So find out where it's at, find out what the status is. If you need any help with that, by all means, give us a call, and we'll help you as much as we can. Okay, I apologize for not pronouncing your name correctly. Kasamoye Sonoy Ryan on Facebook asks if it's okay that my fiance will be present in my interview in the embassy. In most cases, the answer is yes. It really depends on the embassy, whether they have enough space to allow significant others into the embassy, and also security reasons. Now, you can actually go directly to the U.S. Embassy. You can go to Google or on the internet and just type in U.S. Embassy and the city where your applicant or the alien beneficiary will be attending the interview, and it should come up with that embassy. Once you open up that page, in the upper right-hand corner of the embassy page, they have a little search box, and you can just type in there, fiance visa, spousal visa, and find out what is allowed and what's not. They usually have a pretty good section on there telling you can't take in electronics and what to expect, things like that. It should also have information in there pertaining whether or not you can attend the interview. We also have the country information on our website as well. You can click on the actual country, and it has a whole list of information for each country, and in most cases it does actually state whether or not the U.S. citizen or the petitioner can attend the interview.
Okay, next question is from Chris Jones. My fiancé is a Nigerian and we have a 20-year age gap. We have known each other for 4 years. I went on a visit last year, submitted petition with letters of witness from our friends and family, took plenty of photos, financial support added to petition. What are our chances of denial? First, we have a lot of customers who have big age gap difference, so it's not very uncommon. It will only have you will have to undergo more scrutiny because of age gap. But if you have sufficient evidence, you said you take a lot of photos, you have met more than once, even more than twice, and you have you have documented your relationship, and you also qualify for financial eligibility, I think you are good to go. But as so for financial support, you can check out our calculator. Go to our website, rapidvisa.com, to check if you're eligible based on your income. And but at the end, the decision or the discretion to like approve or deny your petition will depend largely on the adjudicator, the immigration officer. So yeah, as much as possible, gather all the evidence and meet all the requirements, and if you're able to do that, I think you're good to go.
Flix Nature on Instagram states that I was denied a B2 visa and F1 visas in 2014 and 2015. On my F1 visa, I used my uncle's name as my father. Reason he was the sponsor. Now I'm going for a CR1 interview next month. Is this a red flag for me? That's difficult to say. It could be a red flag if it comes up that they find out there was any immigration fraud, meaning you basically provided incorrect information on any forms. But in most cases, it's been our experience that previous filings for other visa types like B1, B2 tourist visas do not cause any issues. Matter of fact, many of our customers have applied for and been denied on tourist visas before filing for fiance visas, spousal visas, things like that. On the F1 visa, again, many people have applied for F1 visas and been denied on those types of visas. The approval rates for CR1 spousal visas are much higher than the B2 visas and the F1 visas. But probably your only concern is going to be providing your uncle's name as your father. You may want to be prepared to explain that to a consular officer if they ask about it. And I can assure you, I've attended the process with my wife when I went through the interview, and they'll bring up everything. The adjudicating officer has access to a database that has information that most people don't even know about. So be prepared to speak to it and explain why you answered questions in the way that you did, and just expect to do that.
Okay, next question is from Rose. Hello, if I want to sponsor my girlfriend and her 2 kids, how much will I need in my bank to get approved? No, it depends on the petition you're filing. If you file K1 visa, the financial requirement is that you have to meet 100% of the poverty guidelines, which like for instance, if you have household size of 2, you must meet around 17,000 a year. But if you're filing for a spousal visa, the income requirement goes a little up. It is 125. You have to meet 125% of the poverty guideline. For household size of 2, you have to at least have around 22,000 a month. But if you need more information on that, you can check out our website, rapidvisa.com. We have a calculator for that as well, or you could give us a call. Now, if you're currently employed and able to meet the income requirement, I don't think you need a bank statement in order to supplement your income. But if you're using your savings or checking deposit, the USCIS will only consider 1/3 of that amount. So for instance, if you have $100,000, then they will only credit 1/3 of that, which is around $33,000. So that's the difference. But usually we at RapidVisa, we don't recommend using assets because it's documentary requirements are tougher. It's hard to prove. We usually highly recommend to get a co-sponsor if you are currently unemployed, rather than using assets.
Now, because they stated that this was the girlfriend and two children, I'm wondering if they're also referring to maybe the tourist visa. If you're trying to sponsor them on a tourist visa, the U.S. citizen really doesn't sponsor the applicants on a tourist visa. So if it was a B1, B2 visitor's visa, then the money would need to be in the applicant's bank account and prove that they can afford the trip. So you really didn't specify, because usually I hear this question quite a bit from some of our customers, stating that they think they have to sponsor someone on a tourist visa, and that's really not the case. That's more for business purposes and not so much personal or pleasure when you're coming over to visit the state. So if we didn't get that question correctly, feel free to give us a call and provide a little more information, and we'll get the correct information for you. Duncan Urbank on YouTube asks, is it possible to choose which office the USCIS or the U.S. processes your spousal visa or to transfer? I've heard testimonies of some offices processing faster than others. Very good question, and unfortunately, no, you cannot choose the processing center or USCIS office where your paperwork is sent to. It's going to be sent to one of two lock boxes, either in Phoenix, Arizona or Chicago, Illinois, and they'll basically receive your documents, and then they use a process which we refer to as load balancing. They'll try and pick out which processing center across the country has the fewest number of cases or a less caseload than the others. And you are right. You can look online at the processing centers to see their current processing times. You can check California, and you can check the Eastern Processing Center, and as well as in Missouri. And you'll find they all have different processing times. Dallas has different processing times. Unfortunately, though, those processing times, I'm not sure how current and accurate they are. Because when I was going through the process with my wife, those numbers just were way off. And they're constantly switching caseloads. We get memos all the time from the USCIS that they are transferring cases from the California Processing Center out to the Eastern Processing Center, vice versa. So to answer your question, no, you can't choose. That's already, a process is already set up for that. And it's quite possible that your case will be transferred. The good news is when it gets transferred, usually that means they'll hopefully be working on it sooner rather than later. So it's good news when you hear that they've transferred it. As in my wife's case, we were approved shortly after it was transferred, because I believe it takes priority when they do that. So hopefully that answers your question.
Next question is from Mike Berthold. Once the visa is approved at the embassy, what is the typical time for you to have the visa in hand for travel? Okay, so once the visa is approved, once the application, the petition is approved at the embassy, it will be sent to you. The visa will be attached to your passport, right? So it depends on the country. If your mailing system is very efficient, then you will receive it within a week or 2 weeks. It depends on and also it depends on the courier. In the Philippines, we have the DHL and the LBC. It will take them 2 weeks for you to receive your passport with the visa attached to your passport. So, yeah.
Yeah, usually it's about 7 to 10 business days, but we caution everyone out there, please do not make travel arrangements and purchase any airline tickets until you have that visa in hand. We've heard too many cases where they've purchased plane tickets thinking that they would have that visa in a week, and as Pam stated, it truly matters and depends on the delivery system in your particular country. So just be cautious of that. Ampon Coach states that my fiance and I are active on social media, but we are not putting anything about our personal life in social media. Would that be an issue for my K1 fiance visa? Very good question, because now, as you've probably heard or read in the news, USCIS and State Department are looking into social media now, and we've actually received requests for evidence or RFE letters requesting copies of social media. So in your case, it may not be an issue or a problem that you don't have anything in there about your relationship, but if you actually want to prove that you intend to marry and you have a bona fide relationship, it definitely wouldn't hurt your case to have that type of evidence. And don't be surprised if the consular officer requests to see copies of your social media accounts. They may also want to see any letters that you've sent to each other, chats, any financial support that you've provided. I mean, again, we're trying to paint a picture here that you have a bona fide legitimate relationship, or if it's a fiance visa, that you have a true intent to marry within 90 days of the alien beneficiary entering the United States. So there's different requirements for spousal visas and fiance visas, but social media is now one of the things that they're looking at.
Okay, next question is from Facebook, from Asnar Narciso Docina. My fiance made a petition for me, fiance visa. It was approved, so the embassy sent me a letter and instruction, but said my ex passed away. Can I still continue his petition even if he died? I just want to visit his grave and meet his sister and uncle. First of, we are really apologize. I mean, we are sorry to hear that your fiancé passed, but unfortunately, since K1 visa is non-immigrant visa, it will not be completed until you get here and get married within 90 days. So you cannot continue the process once the petitioner has passed away. So what you can do to visit your fiance's sister and uncle is to apply for a tourist visa, B1, B2 visa. We also offer that service. You can just go to our website, rapidvisa.com. But you really have to prove that your stay is temporary and you're not intending to stay here in the United States permanently. So it depends on your intention. But sadly, B1, B2 visa, the approval rate is pretty low. But it's possible you can get the B1, B2, and then get here and meet your fiance's relatives.
Shirian Hamlet states that my green card application was sent to USCIS via your service. How will I know USCIS received it? There's a couple different ways you'll know. First, you should receive a notice of action letter. It's called NOA1 or receipt notice. That usually comes within approximately 2 to 3 weeks after we submit your paperwork. The second way to know is if you wrote a personal check, check with your bank to see if that check has been cashed and cleared. If that's the case, you know it has been accepted. The third and final way that I know of is just simply to call the USCIS. They're going to ask you for personal information, your name, birth date, address, things like that, and you should be able to find out whether they've received it. But the first and most common way is to receive that NOA1 letter or notice of action. And it'll have your case number on there. It's very important that you retain that letter with that case number. You're going to need that down the road. I know a lot of people discard those letters. They lose those letters. Make sure you hang on to that. And if you have not received it in a timely manner, definitely do not wait any longer. I would definitely call the USCIS just to make sure that everything was received. And then once you have that case number, you can also check the status of your case online. So it's very important to get that case number.
Next question is from YouTube, Muhammad Folosin. I applied for CR1 visa for my wife and everything went well. My question is, how long should I wait before I apply for my two brothers, and what's the documentation that I'm going to need? Thank you. I don't think you need to wait as long as you're able to. Well, the most important point here is that if you're applying for like 2 or 3 person, you should be able to meet the income requirement at least at the NVC stage. So, but if you're employed, you're currently employed, you're able to provide them with all the documentation, you meet the income requirement, then you should be good to go. You don't need to wait. And as for the documentation, the usual things they require for petition for alien relative is like birth certificates proving you have the same, at least one parent, you have the same parent, and your U.S. proof of citizenship. But yeah, it depends on your situation. If you have more question on that, we can help you. Just give us a call or go to our website, rapidvisa.com.
Louis Lagardo on Facebook states that my wife's interview is in Manila on July 15th. Is there any advice to give her? She was thinking of visiting the RapidVisa office there after her medical exam to make sure all the documents are set for the interview. My mom is sponsoring our visa, so I'm wondering if there is anything we need to know before the big day. Thank you. So a couple of things. Yes, your spouse can definitely visit our office in Manila on Rojas Boulevard, which is directly across the street from the U.S. Embassy there. And we can definitely review your documents and make sure everything is in order, and also kind of prepare you for the entire process. We don't really believe in coaching or training or anything like that. The consular officers can pick up on that really quick if you've been coached. So what you really want to know is just be very familiar with each other. They're going to ask some personal questions about where you work, where you live, things like that. If you have children, just go through the entire petition together. And then as far as the mother being the joint sponsor, just make sure all the financial documents are in order. W-2s, pay statements, things like that. If they're using any assets, you'll need proof of ownership of assets, and you'll need appraised values of any assets. But as far as preparing, your spouse, you just want to talk to each other, go through the petition, because everything that you need to know is in that petition, believe it or not. All the answers are in there, all the information's in there, because that's really what the consular officer is going by. They'll just open up the petition, flip it page by page, and they're just grabbing bits of information right out of the petition. So if you're familiar with that, you should be good to go. And if there's any answers that your spouse is not familiar with or does not know the answer, do not be afraid to say no, or maybe try to ask the consular officer to explain the question if they're not sure.
Next question is from Bernard Amanatori Tiltifio. I'm sorry, I butchered your name. How long does it take to receive your SSN once you applied AOS, especially when you receive a letter that they want to verify before approving the SSN? Based on our experience, a lot of our customers usually receive their SSN after they receive the combo card. At least that's what we're seeing right now. They usually receive it 1 to 2 weeks after they receive their combo card. The combo card, it looks like a driver's license. That's your authority to work in the United States and also authority to travel outside of the United States. As for the letter, they receive a letter stating that they want to verify. Yeah, so if you receive the combo card and you have not received your SSN after like 2 or 3 weeks, I think you need to call the Social Security service, just verify, because I'm assuming that after they approve your travel and work permit, they will send it to the Social Security. So if you're having trouble with that, it's best that you call them.
Yeah, that is.
Yeah.
It's an automatic process. They'll automatically send notification over to the SSA, Social Security Administration. So just contact your local SSA office. They should be able to direct you to the appropriate authority or office and be able to track that down. If not, they may even be able to just issue a card for you right there. But just about every city has a local office. I would check there. Lewis on Facebook asked how many times I have to send to MVC documentation that they request. I'm not sure if you're receiving a request for evidence. Maybe that's what you're referring to. But just to explain to everyone out there, the MVC process is pretty complicated, especially for the spousal visa. This is where you have to pay the MVC fees and you have to submit affidavit of support and financial documents. You also have to submit the civil documents. And this is also this stage and process where we see a majority or a lot of the RFEs request for evidence. So if you're asking how many times that you have to keep submitting these documents, well, you'll keep submitting them until the MVC reaches out to the embassy and gets an interview date. So basically, when they're satisfied, when they have everything they need, they'll tell you that they have everything they need, and they'll reach out to the embassy, and then they'll provide you with an interview date. Otherwise, if they don't have everything, the MVC is the one agency who will keep issuing RFE after RFE until they get everything. That's not the case with the USCIS. Usually with the USCIS, you get one shot to comply with the request for evidence. Same way with the embassy and the consular officers. You get one shot to comply with an RFE. With the MVC, we've seen probably 2-3 RFEs, and they'll just keep sending them until you comply and have provided everything.
Okay, next question is from Facebook. Mavis Okechukwu Anekwe. If you're approved and you come to the USA, how many years would your green card be for? Okay, so I'm assuming you are asking for the for validity or the expiration of your green card. Well, if the beneficiary receives the 2-year green card, the conditional green card, it's only, of course, valid for 2 years. After that, you need to remove the condition, file a removal of condition, ROC. That's form I-751. So in order to remove the condition, and then you will receive a 10-year green card. If you have a 10-year green card, well, within 90 days before the expiration of your 10-year green card, you need to either, file naturalization or renew your green card. So same process as the I-90. No, it's I-90 to renew your green card. Not same process, but yeah, it's I-90, not I-751, in order to renew your green card that is about to expire.
I think EISD Railheck. I apologize for not pronouncing your name correctly. We do the best we can with some of these names. Can a sponsor of a CR1 spousal visa who also has a co-sponsor be Medicare federally funded insurance? So the short answer on that is you cannot collect means-tested benefits and sponsor someone. So you would have to look up to see if your particular benefit is considered to be means-tested benefits or not, or if they're exempt. The U.S. Department of State does have a list of benefits that are exempt and not considered means-tested. I'm not sure if the particular one that you're mentioning is Medi-Cal federally funded. So maybe you could give us a call back and let us know exactly what you're receiving. We could look that up for you, or you can just go online and check. They have a list of all of the benefits that are exempt and which ones are considered means-tested. But to answer your question, and for everyone else out there, if you're collecting means-tested benefits, more than likely you're not going to be approved on your affidavit of support. Therefore, you are not going to be able to sponsor someone and get approved for the immigration benefit you're applying for.
Next question is from Miche. Miche, since USCIS offices are closed, what would be the estimated timeline for K1 visa? So I'm thinking you're referring to the USCIS field office that are closed, that was recently closed in the Philippines. Yeah, but yeah, it's just the field office that was closed in the Philippines, not the U.S. Embassy. The U.S. Embassy and the USCIS field office are two very distinct and different offices. And your interview will be done not at the USCIS field office, but at the U.S. Embassy. So currently, but it doesn't affect your K1 visa. But currently, because of increased scrutiny, we are looking at for K1, we're looking at about 7 to 10 months timeline. But it depends. Again, it depends on your situation. So it could be shorter, it could be longer than that.
Colton Noor on Facebook states that I'm a refugee and got a green card now he's a permanent resident. Can I also apply for my fiance for the visa? So no, you cannot sponsor someone on a fiance visa if you are a permanent resident or green card holder. To sponsor someone or petition someone on a fiance visa, you have to be a U.S. citizen. Now, you can sponsor or petition someone for a spousal visa. Unfortunately, it's taking about 2 to 3 years, though. It takes a lot longer than if you were a U.S. citizen. If you're a U.S. citizen, it's taken about 8 to 10 months to petition someone on a spousal visa. But if you're a green card holder or permanent resident, you're probably looking at 2 to 3 years. But to answer your question, no, you cannot petition someone on a fiance visa.
Next question is from Melania. Can my fiance come to visit me in Europe while K1 visa is processing? Well, the answer to that is yes, and you're encouraged to, because when you're filing K1 visa, you have to document as much as possible your physical meeting, and you're even encouraged to meet not once, but twice or more than twice. So yeah, you're encouraged to meet as much as possible and document everything. Take photos and save your travel itineraries and all that. And but because it doesn't restrict the U.S. citizens' travel. While on the other hand, if you're the alien or if you're the beneficiary, you might have trouble getting access to the U.S. while you have a K1 pending. So, but yeah, no trouble or problem meeting in Europe if you have visa to enter Europe.
Someone on Instagram asked, do we need to have proof on social media that we are together, as we are both private people and don't like to put our personal life on social media? Does this play a big part of our petition? This probably depends more on the type of petition you're applying for. For a fiance visa, to show that you've met, you just need to provide photographs of the two of you together and stamps in your passport. It's really that straightforward and simple. On a spousal visa, you're going to need a little more proof that you have a bona fide legitimate relationship. It doesn't matter if you're both private people or not. If you're in a bona fide legitimate relationship, you should be able to provide proof of that. Otherwise, the consular officer is going to have a difficult, if not hard time believing you actually intend to be married, and they may think that you're just doing this for an immigration benefit. So again, it depends on the petition type. For a fiance visa, you just have to show photographs of the two of you together, stamps your passport, show that you've actually met. It's that simple. Spousal visa is a little more complicated than that.
Okay, next question is from Jacobson Francis. What's the timeline for EAD and AP for K1, and can it be expedited? What's AP? Do you know what's AP?
Advanced parole, and EAD is Employment Authorization Document. And
for
they're just
K1.
asking.
Yeah, so for K1.
Well, this would be probably an adjustment of status.
Yeah, right. Because
So
for
after
K1,
they come here on a K1, then you can apply for the EAD, but it's only valid for as long as the fiance visa is valid for. So.
I see. Okay, and can it be expedited? I don't think you can expedite it. Yeah, so I think you just need to wait once you applied it, and you'll wait for approval.
You're really better off looking at applying for adjustment of status. A lot of folks come here on a K-1 and try to apply. They want to work immediately. We all understand that because the AOS process is so long. It's taking anywhere from 10 to 12 months to get their green card. But unfortunately, your K-1 visa is a one-time entry visa, and it's only valid for 90 days. I can tell you from experience that by the time you submit all of your paperwork for advanced parole, the I-131 and your EAD application, it's going to take longer than that to get it processed. So your visa will already be expired, and there are fees associated with each of those forms if you file them separate from the I-485. So again, I would, probably just wait a while, do the right thing, apply for adjustment of status. Because I haven't seen one work out yet. With the visa only being valid for 90 days.
Yeah, true.
Anonymous. My Form I-130 is approved. What is the next step? How will they contact me? I am the beneficiary. After the USCIS approves the I-130, it will forward the petition to the National Visa Center. National Visa Center will, let me just take this, I'll just separate, okay? So if your I-130 is already approved, then they're gonna send it on to the National Visa Center. And what happens there is they're gonna send you an invoice. They'll send you an email message, and the invoice is for the MVC fees, okay? You have two fees. There's the affidavit of support fee, which is $120, and then there's your visa application fee, the $325. Altogether, it's $445 is what you're going to pay to the National Visa Center. They're going to give you a detailed checklist of all the supporting documents you're going to need. You're going to provide your affidavit of support, W-2s, proof of income, your pay statements, things like that, IRS transcripts. For civil documents, you've got to provide your police reports, your background checks, and they're going to want to see birth certificates, divorce decrees, all that stuff. It's quite a detailed checklist, so follow that. If you have not received that communication, I would say within 30 days, a month after you've received your approval notice at the USCIS, I'd go ahead and call the MVC. If you go to the U.S. Department of website, it actually states do not call them until after 60 days. For me, 60 days is probably a bit too long because to me things can go on. I would just, if nothing else, call them, make sure they've received it. Now they'll tell you they haven't reviewed it or processed it yet, but at least you can confirm that they've received it. And then you may wait a few weeks after to receive that communication, that invoice, and that checklist. But by all means, if 60 days have gone by and you haven't heard anything, I would be calling them constantly, and they also have an email inquiry address that you can reach out to as well.
Okay, next question is from Stanley. What if a person just cannot find a joint sponsor? Oh, okay, so the income requirement is very vital, so there is no getting around the affidavit of support. So if you are not able to provide a joint sponsor, we suggest you use the qualifying assets. But as I said earlier, assets, they only consider, it has to be liquid assets, and they only consider 1/3 of the value of the assets. So if you have like 100,000, they only consider 1/3 of that, which is 33,000. So they will not consider the whole value of the assets. That's the downside of using assets. And if you're also providing, for instance, real property, the documentary requirements is also tougher because you need to have third-party verification like appraisal from a licensed appraiser, and you also have to prove that you wholly own the property, and because sometimes most of our customers will provide a deed, right? But like there are 5 people on the deed. Usually that is not really sufficient. They usually receive an RFE for that. So yeah, it would be tougher, but yeah, just get your income up, and I think providing a joint sponsor is the best route. And a joint sponsor could be at least 18 years old and living in the United States, either a U.S. citizen or green card holder. And of course, he must be able to meet the income requirement.
Just a couple things to add to that. Not every U.S. embassy accepts joint sponsors, especially for the K-1 fiance visa.
Yeah.
So keep that in mind. Also, in regards to assets, everything comes down to the discretion of the consular officer reviewing your case as to whether or not they'll even accept assets. So for whatever reason, some consular officers do not accept them. And then also the proof of assets is very subjective, and the value of those assets is very subjective. So you may think that your property is worth $100,000 and the consular officer says, one, we're either not accepting it or we don't believe in it. Now they won't share this information with you. They're not going to tell you. They'll just stamp denied.
Yeah.
But in most cases we've seen it's because they do not accept assets. So it's probably in your best interest to look at having a joint sponsor or getting your income up in some way. Unfortunately, though, you need to show sustained income over a period of time. They're looking at 3 years, not just the last 6 months, last 12 months, what have you. Mark Shockley on Facebook states that I had a spouse from another country. That marriage failed. If I remarry someone from another country, should I seek a fiance visa or spousal visa? A lot of people ask us this, and there's pros and cons to each. Fiance visa, you're going to find, is probably a little less expensive up front and a little bit quicker. There's about 2 to 3 months processing time difference between a spousal visa and fiance visa. Spousal visa taking longer, of course, and it's more expensive up front. But in the long run, spousal visas can be less expensive because the spousal visa includes the lawful permanent resident card or the green card, whereas the fiance visa doesn't. So with the fiance visa, you get the visa and then you travel to the U.S. and you have 90 days to marry, and then you have to apply for what is called adjustment of status to get the green card. So when you add the 7 or 8 months time frame with the K-1 fiance visa and the year, 10 to 12 months on a adjustment of status, you're looking at almost 2 years to get a green card. Whereas a spousal visa, you're looking at 8 to 10 months. You get the spousal visa, and then as soon as you enter the United States, approximately 2 weeks after entering the U.S., you'll receive the green card. So it really comes down to, are you wanting to get your fiance to the United States as quickly as possible? Do they need to work? Do they need to travel? There's a lot of questions that need to be answered. But like I said, there's pros and cons to each. And it also depends on the country that you're getting married in. For instance, if you're getting married in the Philippines, it can take you up to 60 to 90 days just to get your certified marriage certificate. It has to go through the PSA, which is the Philippine Statistics Authority, and that can take very long. It can also take you up to 2 weeks just to get married in the Philippines. So not to spend too much time on the Philippines, it's just I know a lot about it because I got married in the Philippines, and I can tell you the entire process. So it really depends on the country and your situation. We also have quite a few tools available on our website that can help you make this decision that compares the pros and cons. So be sure to check that out as well.
Okay, next question is from Willia K. Dio Campo. Can somebody be denied for removal of condition application? Yeah, absolutely. This process, the removal of condition, is this will be the last chance, the last time that you have to prove to the USCIS that your marriage to your U.S. citizen spouse is bona fide, it's genuine, it's legal, and it's not for the purpose of getting an immigration benefit. So this will be your last time to provide evidence establishing that fact, but that condition. So if you slip on your application, there is a big chance that you'll get denied. So what you need to do is to like gather everything, all the documentary evidence like joint lease, joint ownership of properties, joint bank accounts, joint filing of taxes. The best thing is even the birth certificate. If you have children together, that is the best evidence that you could provide. But as I said, if you slip on your application, then definitely you will be denied.
Well, thanks for joining us today. Be sure to like, comment, and subscribe to our YouTube channel to get alerted whenever we post new videos. Check out our channel to see if you have a question that has already been answered. Our giveaway today goes to Natasha Hayes, and congratulations on your $100 RapidVisa credit. Please claim it by sending us a private message. Thanks again, everyone, and we'll see you next time. Take care.
Thank you for joining us today. We apologize if we didn't have time to answer all your questions. However, you can always contact us by phone or chat to answer your questions. We want to remind you that RapidVisa is not a law firm and is not licensed to practice law in any state. The hosts of this show are not attorneys. RapidVisa is a document preparation firm licensed and bonded in the state of Nevada. If you need help with your immigration petition, check us out. We've helped over 30,000 customers from 180 countries apply successfully. Check out our testimonial library at rapidvisa.com, where we have over 1,000 photo testimonials from actual customers describing their immigration journey with RapidVisa. There's no cost or obligation to create your RapidVisa account. You can create your free account at rapidvisa.com/free. Be sure to like and follow us on Facebook to be notified of future live streams. Thank you and see you next time.